Hello, everyone. Good afternoon, and welcome to the second of our briefings this week on the UK government's new immigration white paper and what it means for employers. We're very glad to have you all. Now, in our first session on Monday, we delivered, I guess, a whistle-stop tour of all of the key provisions in the document. And we are not going to do that in this session simply for reasons of time. But if anybody didn't manage to catch that on Monday, we will be recirculating a link to it so you can catch up there. Instead, the focus of today's session is going to be analyzing what these key policy changes will actually mean for employers in the UK. And we're going to kick off the session by answering some of the questions that people left us in Monday's session. And we also urge anyone watching to send in any more questions that might arise using the comment chat function, and we will do our best to answer all of them at the end of this session. But let's kick off with this last session. So GJ asked us the rise in the immigration skills charge from £1,000 to £1,320. Is this just a proposal at this stage with no definitive date set? Sam, do you think you can answer that?
Yeah, hi everyone. First of all, great to be back on the call. So thank you, Alex, for bringing me on. Just to start off with this first question, it is only a proposal at this stage, as with everything else in this white paper. So the proposal on the immigration skills charge, the 32% increase, it would mean that for large sponsors, the annual fee, the annual sponsorship fee would go from 1,000 to 1,320 per year. But again, it is just a proposal at this stage with no definitive date set on when this will be implemented into law. You know, it is possible that the government will look to do these policy implementations through a staggered approach where they implement them over a long period of time, depending on when they can get them through the legal proceedings, when they can get them through Parliament, etc. And it's my view personally that this immigration skills charge will be one of the first policies that the government will look to implement. So if you're a business, whether large or small, because it accounts to both small and large sponsors, you will need to start looking at the potential budgetary implications of this. And we would recommend to start doing that now, just in case the Home Office do release some form of statement of changes in the coming weeks where they try and push this particular proposal through in an expeditious manner.
Great, thank you for that, Sam. And now we have another question left for us last time, this time from Galina Saprokina, I hope I'm pronouncing that correctly, who asks, will there be equivalent in the sense of years of experience and or training or certification to a degree, given that the skills threshold for the skilled worker visa is being raised to RQF level 6, which is a bachelor's degree equivalent, and because not every high-level skill is acquired via a degree. For example, field welders, whether in service or subsea.
Yeah, no, it's a very, very good question, Galina. And the answer to it at the moment is that, you know, whilst the specific details on how the RQF level 6 increase will work will be implemented, it has previously been the case where RQF level 6 occupations did not all require someone to hold a degree level qualification in order to be eligible to them. Whilst they are advertised as degree level occupations, it is not always the case that the applicant in question has to hold at least a bachelor's degree. So we would need to wait for the Home Office to release more specific details about which codes could be eligible without someone holding a degree level qualification. But again, that's something that we need to wait on the Home Office to release and confirm before we can provide more sufficient advice on how that will be sort of implemented going forward.
Yes, absolutely. There's still a lot to be disclosed in the document. And we've got another question from GJ here. This is on adult social care, which is, as was eye-catchingly announced on Monday, being now banned from overseas recruitment. And GJ is asking whether this looks like it'll be immediate. Is this correct, or is it still at the proposal stage at the moment? And do we know when this will actually come into force?
Again, a very good question, and again, something which hasn't been specified within this white paper. The document itself is just a proposal at this stage, didn't contain any information really about when these policies will be implemented. I do believe, again, though, personally, that the Home Office will adopt a staggered approach to these policy implementations. And as with the immigration skills charge, the closing down of the health and care visa route for overseas recruitment will probably be something they will look to implement sooner rather than later. So again, it is something that if you're a care provider, if you're on this visa route, you would need to be taking those precautions we would advise now, sort of in advance of when the Home Office are likely to sort of look to implement this policy. But again, it is only a policy proposal at the moment. These things do have to go through Parliament. They do have to be agreed within government legislation. So it hasn't been implemented yet, hasn't been confirmed when it will be, but we just do need to keep an eye on this as to further Home Office updates.
Yeah, thank you, Sam. And we've got another question from Galina, which refers to the need for companies to submit a workforce development plan for upskilling the local population when requesting short-term work visas. And Galina wants to know, what if a short-term visa is needed for service provision, such as a fly-in, fly-out mission? Do you think you could shed some more light on that, Sam?
Yeah, of course. I mean, we all have our sort of speculative lens on here as to how this could be implemented, what this would mean for these specific situations. But again, our advice at the moment would be that we have to wait on further Home Office clarifications on this. They haven't specified that in the document. I know there are a lot of questions regarding this, a lot of questions and sort of a grey area regarding other sort of policy proposals, but it is a case of just waiting for the Home Office to provide more specific information about how this will be implemented. And as soon as that's provided, we will be able to share that specific advice and specific guidance on how to proceed.
Yes, thank you, Sam. And our final question from the last session comes from Praveen Kumar. And
Yeah.
Praveen is asking, if a dependent is already in the UK and working, while the main applicant holds a skilled worker visa, is the English language test still required for the dependent when applying for visa renewal or switching categories?
Yeah, again, it's a sort of new piece of proposal. This, I know it's been all in the news. I'm sure we're all aware that the Home Office are going to start requiring adult dependents of those who hold a skilled worker visa to attain English language as well before they can apply for the dependent status. Now, it hasn't been confirmed in the white paper as to whether this will apply to those already in the UK on a dependent visa, maybe extending, because the requirements differ depending on what stage you're at. So what the white paper discloses is that if you're newly applying for a dependent visa from outside the UK, you have to meet the A1 level English language. If you're applying then to extend the visa, the dependent visa, you have to attain A2 level English language. And if you're applying for settlement, on the basis of a dependent, after that you have to meet the B2 level. So that's what they've disclosed in the paper. But again, it is not clear as to whether that will only apply to new applicants after this policy is implemented, or whether it will apply to those already in the UK. I know there's been a lot in the news, and I'm sure we've all seen that people close to the Home Secretary, people close to Yvette Cooper have stated that this will be affecting those already in the UK on these statuses. But again, that is just speculation. That is just talk. Nothing has been confirmed. So we will have to wait until the Home Office confirm the way that they're going to be proceeding before we can provide sufficient advice regarding this.
Thank you, Sam. The ambiguity seems to be pretty prevalent around a lot of the suggested policies in this document. And so we must stress that the nature of the white paper is not a settled piece of policy yet. It is very much a living document. It's a sketch of the government's intent, which they will then seek to pass into legislation. And that may have some modifying effects. But in terms of what we do know of what is outlined in the white paper, we can start to make some kind of assessments about what potential impacts it will have and what the meaning it is going to be for anybody who employs foreign workers in the UK. And there are positives and there are negatives of much of what has been announced so far. And so we think that we shall start off with our analysis by asking, what are the positives for businesses and employers in this white paper? And I think I will get us started here. And I think that one positive is the white paper's reorientation of the UK's immigration system to prioritize high-skilled talent. In the white paper, the government are very categorical that they understand that the UK is in competition with other countries around the world to attract the most desirable and highest skilled talent possible. And the government clearly are seeking to kind of reorientate, to reprogram the system in order to reward that kind of skill level and distinction over just the simple availability of labor. In the words that they've been using in reference to the skilled worker visa, skilled must mean skilled. And this is most clearly manifested in the raising of the qualifications threshold, the RQF threshold for the skilled worker visa to the level 6 role, which will limit eligibility to degree level roles. And while this may cause some short-term headaches, I think, it is, in our view, I'd say a long-run positive factor, and something that we actually called for last month in our own report on the skilled worker visas various structural flaws. And now we hope that this change will create a more sustainable immigration system with uptake that's easier to project than it previously has been. And that may finally bring an end to all of the multiple tweaking that we've seen over the last 5 years that has been really quite damaging for businesses. So we hope that this will be the case. But in the short or kind of immediate term, there are also some new lifelines that the white paper is throwing business looking to hire quality talent. And I think, Sam, you can speak a little bit more on those.
Yeah, of course. Thank you, Alex. Like Alex said, we are seeing these changes. I know there have been a lot of changes over the past 5 years. We're all aware of that. Cost changes, law changes, policy changes. But like Alex said, we hope that this will reinforce the government's perspective on transitioning the UK to a high-tech economy, and that the rate of changes after this will be significantly slowed down. On the subject of additional lifelines that the government have opened up in this white paper, I'm sure we've all seen that the global talent visa in particular has been highlighted as a visa that the government would like to see increased utilization of. Now, at the moment, it is quite an underused route. Normally per year, there are about 5,000, if not a bit less, individuals who are granted this visa, mainly under the Tech Nation stipulation. And I know the government's main focus in the white paper is on AI technology. So what we're seeing, what we'll hope to see, is that there will be greater utilization across the world for individuals who are highly skilled within that digital technology stipulation, particularly in AI, using this route much more than is currently used at the moment. In addition to that, we've also got things such as the high potential individual visa, the HPI visa. Again, quite an underused visa route. It only applies to individuals or graduates, should I say, from 90 universities around the world, what the Home Office consider to be the best universities in the world outside of the UK. This list is being expanded to 180 universities, so it is effectively doubled. We would potentially expect the number of individuals applying for and receiving the HPI visa to theoretically double because the list has been doubled, but of course we'll have to wait and see if that happens. Again, businesses can hire these HPI visa holders. In the UK, they are normally valid for 2 years, but they may be valid for 3 years if the individual holds a PhD. Unfortunately, the route doesn't lead to indefinite leave to remain in the UK. Time spent on this visa doesn't count towards ILR, so they will have to transition to another visa, say skilled worker. But what we may be seeing more of now is those individuals transitioning to the global talent visa. As I said, it is apparently being made easier, so we may see individuals get the HPI visa first. When they come to the end of their duration on that visa, we may see more individuals transition to the global talent, but that again remains to be seen. Just a few other points to pick up on here. We also have the government are apparently going to make it easier and more streamlined to apply for the Innovator Founder Visa, a visa implemented a few years ago and is very, very underused. Only a couple of hundred individuals receive this visa every year. It is quite a strict route at present, and getting endorsement is quite difficult, especially without legal advice. So the government are apparently going to open up this visa to encourage more applicants, particularly those international students coming up to the end of their course in the UK, to apply under this visa and sort of bring their business operations or their new business to the UK labour market. Final point on this is the UK Expansion Worker Visa. Again, it's part of the Global Business Mobility stipulations, and it's for businesses outside of the UK wishing to set up an entity, their business in the UK effectively, or UK entity, sorry. And at present, they can only bring 5 individuals to the UK to help in that company corporation setup here. Under the new rules in the white paper or the new proposals, this would be doubled to 10. And of course, more in this case is always better. The more individuals there are in the UK, the faster the company setup can begin, the greater it can become at attracting that domestic talent or more international talent for that company, and the faster it will be for that company to move on to the skilled worker license. So they're just a few points that we picked out from the white paper of where we could be seeing the UK visa market and the labour market as well moving towards from the current skilled worker utilisation. Pass back to you, Alex.
Yes, thank you, Sam. And it's encouraging to hear that even as some of the thresholds are tightening, there are still going to be routes to hire high-skilled talent, particularly at a lower cost than you get with the skilled worker visa, because many of these visas, such as the global talent visa, do not have the requirement for sponsorship. And so it's a much lower cost route. Now, I think I want to talk now about the benefits for professional development that we can observe from some of the clauses in the white paper, particularly the scheme of earned settlement. Now, many of you will know that the white paper is proposing to double the period during which, before one becomes eligible for indefinite leave to remain, which is, of course, settlement in the UK. But this is being qualified in a way by a points-based scheme by which migrants who are deemed to be making meaningful contributions to British society and the economy through their tax contributions, through the roles that they're performing at work, through volunteering, etc., will be able to reduce this period and win settlement and eventual citizenship faster. Now, this gives companies more of an incentive to cultivate their overseas hires with professional development opportunities to help them progress throughout their careers, and in that sense to speed up their path to a more stable legal status, which I think is a real win-win for both parties. So I think that that is a potential positive lurking within a potentially controversial detail of the white paper. Now, one thing that is more kind of straightforwardly positive is the attempts to streamline the visa system. And the government is proudly touting in the white paper that it's doing this to make it much easier for employers and skilled workers to get visas. Applicants will only have to go to a single appointment at a visa application center to process their biometrics. And from there, everything will be implemented and processed digitally. And it's as yet unclear when this will be instituted from and legislated for, but the white paper promises the process will start at some point this summer. And now, as every business that's ever used the visa system will know, the administration involved can really be a major headache. So I think that this is a decisively welcome change. Would you agree, Sam?
No, 100%, Alex. I mean, it's a welcome change, not only from the employer's perspective, but I think just across the board. You know, if you are a immigration legal advisor, mobility specialist, and the applicant themselves, I think it's much better, much more streamlined having that digital status rather than having a load of physical documentation that you have to make sure you have on yourself all the time, make sure you don't lose. Obviously, if you did lose it beforehand, there is, of course, a fee to have it replaced. So the transition to that digital status across the board now is a very welcome change. And, you know, like Alex said, the details are still unclear. The white paper did outline a few of the proposals, and I think the general idea is that if an applicant goes to, let's say, a VFS center in country A, they would attend the biometrics appointment, submit their biometrics information, but as soon as the visa has been issued or approved, they would be issued the digital status straight away, rather than having to return to the center to collect their passport with a vignette stamp in, or have their passport couriered back to them with the vignette stamped in it. So that is our understanding at the moment, but of course we'll have to wait for the Home Office to officially confirm that via their channels before we can pass that advice on to you guys.
Great, thank you for that very succinct summary of why this is such a positive shift, Sam. Now I'm going to make another point about some of the longer term benefits of what we've seen in the white paper, and that's the investment it proposes in the domestic skills base. And a lot of the reason for the higher costs involved in the white paper, which we will touch on later in greater detail, is to build up the British skills base. And as our own report into the skilled worker visa explored in detail last month, the UK suffers from some really very chronic skills gaps across our most important sectors. And the white paper actually makes the case that the labour market in the UK has been, and I quote, distorted by perverse incentives to import workers rather than invest in our own skills. And now think tanks like the Social Market Foundation have long been calling for the existing immigration skills charge to be more productively invested in the kind of upskilling and training programs that might reset this balance. And now it seems like there is at least a sense of purpose and resolve in government that this has to happen. And now this is very much a medium to long-term kind of consideration from a business's perspective. But if this actually works, then firms will be much more easily able to hire for the specialist roles that they need from the domestic labour pool, rather than shouldering the significantly heavier costs of having to search abroad. Do you think that that is a valid assessment of the situation, Sam?
Yeah, no, 100%, Alex. I mean, it obviously still remains to be seen how this will sort of be implemented longer term. I think, like exactly like you say, it is something to be looked at in the medium and long term. It won't be a short term fix by any means. But I think this government, well, that is basically the plan of the government to have that additional money generated from the immigration skills charge to go back into the upskilling and upscaling of that domestic workforce. At least that is the plan of the government. Again, it does remain to be seen exactly how this additional funding will be used for upskilling or upscaling the domestic workforce, what benefit that will be to current sponsors in the UK as well. But again, it is something that I'm sure we will hear more about over the coming months when the Home Office does tighten and does sort of freshen up this white paper policy proposal that this is included within.
Great, thanks, Sam. And hopefully you can tell us a bit more about one detail that might have escaped people's attention when reading over the white paper, and that's about the employment of refugees.
Yeah, of course. I think obviously not applicable in most instances by any state of the matter, but I think it's still important to take a look at, and that is what the Home Office are now proposing is that refugees who are sort of indicated or in like UNHCR refugee camps across the world who have been identified to hold valuable skills that could benefit the UK economy, these individuals are going to be eligible for applying under the skilled worker route. So a quick detail is that the Home Office are apparently going to make it easier for these individuals to attain the skilled worker visa. And obviously, how that will actually be implemented, what procedural policies, what procedural things we'll be looking at there remain to be seen. But it is just what I think is quite an important point, and that all the negativity we're seeing, obviously regarding refugees, regarding illegal migration, for example, they are actually making it easier for certain refugees, like I say, identified by UNHCR, to come into the UK as those skilled professionals and make their way towards permanent settlement here, most likely under the 10-year route. But again, that remains to be seen as well.
Yes, and that's great news from both a humanitarian and kind of a business perspective. If we can get very bright people who have suffered greatly to be playing productive roles in our labour market, that can only be a good thing. But now I'm afraid we have to segue into some of the negatives from a business perspective for employers of this white paper. And I think you'd agree with me, Sam, that the biggest downside of all is cost. The already considerable cost of hiring from abroad is about to rise yet further. And most notably, the minimum salary threshold for the skilled worker visa and other visas is rising again after a very significant, almost 50% hike last year, this is something that we and others had been calling on the government not to do, but it looks now like the die is cast, and so these prices are going up, and they will have to be budgeted for. And what's also rising is the immigration skills charge, which is, the money that's hypothecated to fund all of these domestic upskilling initiatives that the government is keen to implement, and that is rising. Well, it's not been hiked since it was introduced in 2017. And so to bring it in line with inflation, the white paper proposes to hike it by 32%. Now that's a pretty enormous overnight cost increase that may require some pretty urgent new budgeting for anybody who's liable to pay it. And universities will be a little bit alarmed, perhaps, by the proposal in the white paper that the government they say that they will explore a new levy on the income raised from international student fees. Now, I must stress that that's actually less concrete than a lot of the already still kind of hypothetical proposals that make up the white paper, but it's something that that the higher education sector will want to be watching closely. And now all of these cost increases are obviously going to weigh on companies' budget forecasts and will inevitably spark conversations within companies about whether it's actually cost effective to hire from abroad at all for all but the most critical and hard to fill roles. And this will probably compel firms to intensify their recruitment drives and search harder from among the domestic workforce. And I imagine that this may be precisely the government's intention. I think that this is a desired effect to change behavior in the labor market. Now, there are also some more sector-specific changes that will only impact employers in particular areas. And I think healthcare, or at least social care, is the biggest example of that. And Sam, can you tell us more about that, about the end of the care worker visa?
Yeah, I mean, it's probably one of the biggest pieces of news, I think, to come out of this white paper. I know, obviously, last year, the Home Office removed the ability for dependents to apply on new health and care worker visa applicants. They're now getting rid of the route entirely, a route that was only brought in several years ago. And the white paper clearly describes it. The health and care worker visa is closing for all overseas applicants. Again, like I said at the beginning of this call, the exact date that the route will close is as yet unclear, but I would suspect it would be a policy proposal that would be pushed forward much sooner than some of the other policy proposals in this paper. But again, we have to wait and see what the Home Office sort of act, or how they act in relation to this. Individuals who already hold a health and care worker visa, they will be eligible to extend their current permission, provided they still retain sponsorship or valid sponsorship. And the Home Office have also said there are around 40 to 50,000 individuals in the UK on the health and care worker visa who were working for a care worker sponsor that has since lost their license. And these individuals will be encouraged, if not assisted, to transfer their sponsorship to a new care worker provider, or a care worker provider that still retains valid sponsorship. So they've said that this route will be open to those already in the country until 2028. So it gives us around 2 to 3 years, or gives people around 2 to 3 years. But again, it hasn't been confirmed when exactly in 2028 they're planning to close this route off entirely. In addition to this, I did just want to pick up on a point about cost that my colleague Alex was mentioning. And in addition to all of the stated costs regarding visa applications, regarding sponsorships, such as the immigration skills charge, another cost that may have slightly gone under the radar is the cost for English language. Now, not included in the white paper, but was still enforced at the beginning of May, was the news that the UK ENIC provider, UK NARIC, as I'm sure we're all aware, is doubling, well, not really doubling, but close to doubling their fees for a university degree assessment. In addition to this, they're also closing off the ability to utilize the priority service, meaning that applicants who wish to evidence their English language through a degree that was fully taught in English will now have to wait double the time and pay more to have this assessment generated. So it just incurs additional costs on those applicants wishing to use this route. In addition to this, the English language tests, as we all know, the criteria that you're going to have to meet will be slightly higher. So for a skilled worker, the plan is to go from a B1 to a B2 level, so one step higher. And a lot of applicants, they have to retake tests already. They have to do the tests multiple times before they can get that B1 level. With the B2 stipulation, we expect that to be even harder, and we expect applicants to have to redo these tests multiple times more than they have to at present. So these are just a few considerations to take into account when applicants come to apply for that skilled worker permission. These are probably going to be a few more considerations that the applicant and the business may have to take into account, and they may have to make arrangements regarding work start dates, as to whether the individual is having to use the UK NAIC assessment, as to when you initiate these cases, for example, in order to get the applicants in when you need them. So just a few considerations there to look out for when we talk about these rising costs. And Alex, I think I'll pass back to you to talk a little bit about business compliance.
Yes, thank you, Sam. Compliance is going to be another consideration that is only going to loom larger in businesses' minds as a result of this white paper. Now, earlier this year, the government announced the creation of a new Fair Work agency set up to protect employment rights and guard against non-compliant activity, you know, like people not having their holiday time honoured or salaries withheld, etc. Now, this body will have new powers to inspect workplaces and require more documentation in order to demonstrate compliance. And it will also have the ability to impose civil penalties. Now, this isn't a move that was announced in the white paper, but the white paper does double down on it and make very clear reference to it, which really suggests that businesses who hire foreign nationals will come under greater pressure from this new body to prove that they are not exploiting their overseas hires. And of course, abuse and exploitation that was rampant in the social care sector has been one of the primary reasons why that visa has been abolished. So the government will be very keen to avoid any repeat of that scenario. So the white paper also calls for companies in sectors highly reliant on foreign labor to produce mandatory workforce strategies. And this is a new compliance requirement that some companies may find a little bit onerous, depending on how large they are. And I think Sam can fill us in a bit more about the challenges here.
Yeah, it's a very good point, Alex. I mean, obviously, again, with most things in this white paper, it's a little bit of a grey area. You know, they make reference several times to the fact that companies or sponsors will have to implement this mandatory workforce strategy, but we don't really know what that is. You know, there haven't been many details on how this has to be prepared, what exactly has to be contained within this strategy. But we do know and can expect that it will probably mean having a strategy in place to upskill the domestic workforce. I think that's the main focus of this government, is saying, yes, you may need a foreign worker, you may need someone to come in from abroad, but we want you to also invest in the domestic workforce, getting the domestic workforce on board. And I think that is highly likely as to what the mandatory workforce strategy will be required to do. But again, it's quite unfair in many aspects as to which companies or as to how companies can implement this. You know, we have those startups, we have those scale-up companies, small to medium enterprises, but we also have very large corporations which may already have similar strategies in place. You know, those large corporations with those significant HR teams will have a much easier time at putting in place this mandatory workforce strategy, at implementing it, at creating it. Whereas some of these startups, some of these scale-ups will have a much more difficult time, meaning that they may decide to sort of move their work offshore. You know, if you're a startup in the UK, don't really have a HR team, maybe only have one individual who also does another job within the corporation, you may be thinking, well, it would just be easier for me to hire someone in, let's say, the UAE to do this work that we need, that we would have needed someone in the UK to do. So we may start to see that. We may start to see business movement away from the UK when it comes to startups and scale-ups, because they find the difficulty in implementing this strategy. Again, concessions may be made by the government here. hasn't been made clear in the white paper. So we will need to wait and sort of find out how the government exactly expects businesses to implement these strategies.
Yes, it's another one of those many wait and see elements of this document. But I think that one thing that does ring through loud and clear from the document is that compliance duties for all sorts of employers will be rising. There will be a greater chance of inspections, and in some cases, as it makes clear in the document, some companies will have to fear raids. Now, I feel that that will probably not be too relevant for many of the people listening to this call who are going to be scrupulous and compliant employers. But I think all companies will have to contend with the spectre of UKVI bearing down on them and do whatever they can to demonstrate their immaculate compliance. And so I guess another kind of downside of the white paper for business is that this is, as we've been at pains to point out throughout this briefing, it's a sketch rather than a settled action plan, as so much of this is going to be subject to consultation and, the modifying forces of turning this into a piece of legislation that will be voted on and probably amended in places on its passage through the House of Commons and the House of Lords. And so employers at present really can't be 100% positive about what is going to make it into law. Now, I think that the most eye-catching and significant stipulations of the white paper are almost certain to make it into law, but almost certain isn't certain enough. So we will, of course, make sure to keep everyone updated on any changes as the bill progresses into law. And Sam, you've got a particular example of this to talk about, I think.
Yeah, thank you, Alex. And just to pick up on that point, I think one of the biggest news stories to come out of this white paper is the fact that settlement in the UK, the eligibility for indefinite leave to remain is being increased to 10 years, or is proposed to be increased to 10 years from the current 5 years, so doubling in effect. Now, there's been a lot of speculation, as to whether this will apply just to new applicants, those who apply for, let's say, a skilled worker visa after the law is implemented, or whether it will apply to people already in the UK. And there have been several dates thrown around. I've seen that, some people say it will affect people who came to the UK since 2020, but I just want to confirm that nothing has been set in stone. These are just speculations. The government have not confirmed anything. The Home Secretary has not confirmed anything, nor has the Home Office. So we do just have to wait until this is officially confirmed before we can advise. But as sort of a small case study, I don't remember personally, because I wasn't old enough at the time, but I do know that it was tried in 2006. The Labour government at the time, I believe, tried to increase or tried to propose an increase in the settlement eligibility to those already in the UK, and they faced quite significant pushback in the legal proceedings, meaning it wasn't implemented. So we will most likely see that happen in this case. If the government does want to implement it or does want to impose it on those individuals already here in the UK, already working towards that eligibility, they are going to have to face an uphill battle to get it approved via the High Court. So, nothing has been set in stone. There will be pushback against it, no doubt about that. So at the moment, people should just be aware of what's happening. They shouldn't plan for anything in particular. They shouldn't make direct plans thinking this is definitely going to happen. We just need to wait for further legal proceedings to happen and go from there. But at the moment, unfortunately, we can't provide any further advice aside from that.
Great, thank you, Sam. And we will, of course, provide more details as and when they become apparent on these questions, because I understand that they are probably quite anxiety-inducing for many individuals to suffer from this kind of cloud of doubt. So I think we should start trying to wrap up this session a bit so that we can get to people's questions, because I see that the chat section has been pretty busy. Now, I think that the white paper really does mark a new direction in UK immigration policy, where not only is it reorienting the system towards high skill labor and maybe doing more with less in terms of the numbers of people. I think it sort of treats employers as, in a way, it's asking employers to become strategic partners who have responsibilities to contribute to a kind of national strategy of upskilling and renewal. So it's about responsibility to contribute rather than simply the entitlement to use the visa system to fill roles. Is that something you'd agree with, Sam?
Yeah, no, thank you, Alex, and I would agree with that. And I think just to add on to that point, we are seeing, and what this white paper sort of lays out is a shift towards strategic and sort of value add higher functions of a business away from the sort of traditional and operational day-to-day affairs. I think that's something that the government are trying to push the country towards. I think the Conservative government that preceded this government also tried to do that. So I think in some way the Labour government is sort of a continuation of what the Conservative government were trying to do. But again, we'll have to see how these sort of proposals will be implemented and see if they can achieve that desire to move us to a sort of strategic and high value add economy, which they are quite clearly trying to do with this white paper.
Yes, and I think that there are some, maybe some risks stored up in the way that they're going about this. For instance, with the extension of the ILR qualifying period, this may mean that some talent starts to look elsewhere, to our neighbours with slightly more, with slightly faster or more generous pathways to settlement and citizenship. For instance, Ireland still offers a 5-year pathway to citizenship, or at least eligibility for citizenship. And then when that is attained, because of the common travel area, the person in question would have full access to the UK jobs market anyway. So there are some downside risks stored up. Whether that will be enough to influence many people's behavior is a different matter, not one that I really feel confident expressing a view on. But the questions and the risks are there. But Sam, do you have any kind of concluding remarks?
Yeah, no, thank you, Alex. And it will be interesting, to be honest, to see whether that does majorly influence people's decisions, but also if it starts to influence people's decisions, whether it will also start to influence UK policy proposals, whether there will be that political power utilised to try and force Ireland to change its policies, for example, or cause a sort of treaty reorganisation with Ireland and the common travel area. So it'll be an interesting sort of thing to keep an eye on, keep a watch on. But basically, I just want to finish off by saying that this white paper does indicate and does move us to the position of shifting away from attracting people across all sectors, all job sectors or work sectors, and only seemingly focusing on those in those higher and much more techier sectors. I know I mentioned AI earlier, and the reason I did is because it has been specifically outlined within the white paper document that is an industry that the Home Office are looking to attract more people here to the UK on, particularly those through, let's say, Tech Nation endorsements via the Global Talent Permission. However, whilst this transition to that higher tech sort of immigration market may lead to the successful transformation of certain areas of the UK to that higher tech sort of area, it will also lead to significant issues across the remaining parts of the UK that are heavily dependent on the care sector, for example, parts of the UK that are heavily dependent on income from international students as well. So there's universities across the UK that are now reliant somewhat on that international student sort of income. So I think we'll leave a lot of areas of the UK a lot worse off. Some areas of the UK will definitely be improved by these white paper proposals. But again, we have to sort of wait and see how exactly these will be implemented and what effects they will have over the coming months and, of course, years.
Yes, thank you, Sam. That's a very pertinent point about the question of potential regional disparities becoming worsened by this move from an all-sector treatment of the immigration system to a more bespoke one for higher value sectors. Now, I guess while everything is still so up in the air and sort of unclear, our advice is just start preparing for this shift now, in whatever way you can, and that's by changing your mindset of how you hire to prioritize kind of high value add roles that have kind of critical strategic functions, looking into your expanded opportunities through the visa routes that Sam spoke about earlier to take advantage of them to hire some of the world's brightest top talent, but also start making budgetary forecasting arrangements now, because some of these cost increases really will be significant, and start thinking about how you can meet all of the elevated compliance requirements that may be coming your way. Now, I think that we just have just about enough time to answer a few of the questions that people have been leaving us throughout the session, and we probably won't be able to get through all of them in the time we have left, but we will do our best to for anybody whose question doesn't get answered, we'll do our best to get back to you individually. So I think the first question we have from Yogita Hirani, will the 10-year requirement for settlement mean the cost to sponsor a skilled work visa mean that cost will increase and almost double?
Yeah, it's a very good question, and if we take the proposals as sort of law at the moment, if this does get implemented, the 10-year requirement, then we are going, unfortunately, businesses and individuals are going to see those costs significantly increase. Most businesses I know at the moment currently sponsor an individual for 3 years in the first instance, and then normally do 2 years or 2.5 years after that to push them up to the 5-year eligibility. Businesses are obviously going to have to make amendments to that now. We may see more businesses start off with the 5 years and then another 5 years after that, the fees for which are obviously higher than the 3-year visa or the less than 3-year visa, and doing it twice will, of course, basically incur a doubling of those fees. So it is something that businesses and individuals are going to have to take into account. And when those budgetary sort of amendments are made, it's something that's going to be a key part of that, I think, is, how long do we sponsor this individual for on the first instance? And also, are we willing to sort of make those budgetary payments, which are obviously going to significantly increase with the immigration skills charge increase and also the doubling of time for indefinite leave to remain.
Great. And now we have some questions from Julia Pechlov. Would a person on a spouse visa who is married to a British citizen be exempt from recent ILR eligibility changes? And specifically, do you think that they could still apply for ILR after 5 years instead of 10?
Yeah, again, it's a very good question, Julia. And I think it's something that's been noted that the family route or family visas in particular haven't really been touched by this white paper. There were 1 or 2 pages maybe on it, but there haven't really been any concrete proposals on reducing this visa number, or increasing the scrutinization of them. So at the moment, our understanding is that these individuals would still be able to apply for indefinite leave to remain after 5 years. So that applies to, say, like a spouse or a partner of someone on the Appendix FM route. So we would still expect them to be able to apply after 5 years. But again, if the Home Office do want to increase that to 10 years, I'm sure we will find out in the coming weeks and months. So it is something, again, we just have to keep an eye on. But of course, when that is released, if it is released, we will provide you with the correct advice on that.
Great. And we've got a question from Jordan Wallace. Is there any anticipated exceptions in getting ILR in fewer than 10 years, perhaps if the individual is proven as economically valuable in their field? Now, isn't that what the Earned Settlement Programme seeks to put in place?
Yeah, exactly. I mean, it is sort of laid out in the white paper, Alex, as I'm sure we've all read, that if an individual is considered, I guess, valuable to the UK, they can apply in a lot sooner time than 10 years. Again, it's not specified that it could be after 5 years. That is just speculation at the moment, but there has been said if the individual is economically valuable, economically viable, and has seemed to have progressed their life in the UK in a positive manner during that time, the eligibility for that individual may be decreased. Now, again, it is very much a grey area at the moment. We don't exactly know what the criteria would be for that individual. So it is something that will be written into law, written into the legislation when it is agreed and approved by Parliament. But at the moment, we can only make speculation on what that individual would be or have to do in order to meet that criteria. Again, when it's written into law, we'll be able to provide you first-hand advice on how exactly that will be implemented.
Thank you, Sam. And we've got a quick question from Sarah Ashton, who wants to know, are there changes proposed for spouse visas?
Yeah, again, Sarah, just on my one of my previous points there, it hasn't really been touched on in the immigration white paper. There haven't been too many policy proposals regarding the spouse visas, regarding that visa under the Appendix FM route. So, there wouldn't be anything we would be able to say at the moment to say this is definitively being changed on this route, this is definitively being added or removed, etc. Hasn't really been touched in the white paper. So at this stage, we would say that route has been left untouched through the most part. But I'm sure the government will sort of lay out their entire plans, if they do have any, for that route later down the line. But at the moment, it does seem to have been unscathed in a way from the Home Office policy proposals.
Right, thank you. And I think we've got time for just one more question, and that's from Alexa Behari. And Alexa wants to know, when do you think they can realistically pass legislation on these changes? As, of course, she is correct to assume that this is still a proposal.
Yeah, Alexa, I mean, it's something I wish we all knew. I'm sure we wish we all knew, exactly when these policy proposals are going to be implemented. The reality is no one knows. The government probably doesn't even know yet. Like I said, they have to go through many different stages of government, of legal challenges, consultations, as my colleague Alex said before they can implement these proposals. What I suspect they will do, like I said at the beginning of this call, is that they will implement them on a staggered approach. They will implement certain proposals which will be easier to pass through Parliament, to pass through the High Courts sooner than others. I do think those fee increases for the immigration skills charge will be passed quicker rather than later, whereas some proposals like the 10-year ILR increase are going to take a lot longer to be passed through Parliament. I can't give you a date at the moment. I wouldn't want to give you a speculative date either. So I would just say that we need to keep an eye on this entire process. Whatever sort of proposals go through Parliament, whatever's happening, we will keep you updated here at Centuro. But at the moment, no specific date or dates have been written into policy.
Well, thank you, Sam. And I'd like to reiterate that we will be keeping everybody updated on any new developments as they emerge. So do keep checking back on all of Centuro's feeds, on our on our articles, on our socials, and our newsletter, because we will make sure that people know as soon as they're announced. Now, I think that we are out of time, but I'd really like to thank everyone again for joining us today. I know it was quite a long session with a lot to get through. I'd like to thank Sam for answering all of those questions so ably, and we will be circulating the recording of this session and also Monday's session among all of the registrants, along with our long form article analysing the white paper. So if you want to hear even more from us in our analysis of the government's immigration white paper, then we've got you covered. But for today, thank you everybody for joining us, and we hope to see you again on the next webinar. Goodbye. Have a lovely day.
Thank you, everyone. Been a pleasure.